Bridget Mackay, and you're watching another installment in my video blog series of Making Your Estate Plan. And this blog relates to what is a trust. As I said in my will blog, that is probably one of the most common questions I get at the beginning of meeting with a client and putting together their estate plan. They want to know, what is the difference between a will and a trust, and what should I have? 99% of the time I recommend that they get a trust, and I'm going to tell you why. A trust is a document you hopefully prepare with your attorney. It is like a will in the sense that it transfers all of your assets the way you want it to be transferred on death. So if you have, you get to choose who the trustee is, successor trustee, after both you and your spouse have died, in the same way that you choose an executor in your will. And you get to choose who your heirs are, who your beneficiaries are, what they get, in what percentages and amounts. And you can also plan for things like minor children and transferring assets to them at different ages over time. A big plus to a trust that doesn't exist in a will is that if you become incapacitated during your lifetime by means of a stroke, the onset of dementia symptoms, you know, any number of things that would prevent you from managing your financial affairs, and you have a trust in place, you can avoid having to do a conservatorship or be the subject of a conservatorship. In other words, a trust allows the next person you have chosen, the next trusted person you have chosen, to step into your shoes and take care of you and your financial affairs. Your trust at that point does not distribute to any of your beneficiaries. You are the sole beneficiary, and they have to manage that trust for your sole benefit without any consideration to any of the other beneficiaries. And this is all done without having to go through a court process, where normally if someone becomes incapacitated and there's no one designated to take care of their affairs, then someone, a relative or a caring person, sometimes even a spouse, has to go to court and ask to become your conservator. And again, that's a court process, which always involves, hiring an attorney. It's time consuming, and from that point forward, the court then monitors your actions, or whoever your conservator's actions are, as it relates to you. Often people want to avoid that, and they want this problem taken care of privately, and a trust is a way to do that. And that provision is built into a trust. And that's one of the major differences between a will and a trust. A will does not allow the process of a successor trustee stepping up and taking over things while someone is alive. Another difference between a will and a trust, and a great benefit of a trust, is while you're alive, and this is often why they are called living trusts, you take your assets, let's say the main, most common asset is a home, and you transfer it into the name of the trust. So by the time you're done creating your trust with your attorney, it's going to have a name, and typically it's, Joe Smith, trustee of the Joe Smith Trust. And that is the name that is going to be used on all the assets that you have, with the exception of a few, mainly your home. So a new deed would be prepared, and on that deed it would have Joe Smith transferring the property to Joe Smith, trustee of the Joe Smith Trust. That action alone allows for your successor trustee at your death to distribute your house and your assets free of a court or a probate, and free of all the fees that come along with doing a probate. So that is really the second reason, main reason people, or sometimes the first main reason people choose, and I recommend, having a trust over a will. It's significantly cheaper to administer at the time of the trustee's or trustor's death than a will is going through a probate. If you saw my will blog or the probate blog, you know that it's about 5% of the gross value of the assets are the fees that are paid to the attorney and the executor by law, non-negotiable, in a will probate situation. In a trust, your successor trustee is able to hire an attorney for those things that they need them for, but ultimately the cost is significantly less. An example, I had an estate worth about $500,000, and the deceased person had a will, and it went through a probate. The fees to the executor and to me, per law, non-negotiable, ended up being about $25,000. Around that same time, I also had a trust administration, and the deceased person had a trust, and their chosen successor trustee administered this trust with my help, and the fees that I charged for that help and administration only cost $4,000. So you can see, the significant difference in costs when a person has died and the trust now has to be administered. It is much more expensive to go through probate having a will than it is to do a private trust administration, where the successor trustee can choose the attorney, can negotiate attorney's fees, and sometimes if you choose your successor trustee right, will do most of the work and bring the cost down even more. So that in a nutshell is a trust. Look for future blogs about choosing the rules that are needed in an estate plan.